Yes.
Lordship, they have filed their affidavit in opposition yesterday, Lordship.
You filed an affidavit?
Yes.
Very well.
We need some time to go through the opposition and to file a reply.
Very well. The state has filed its affidavit in opposition. At the time to file the rejoinder is extended till a fortnight from date. Paragraph, the matter will appear 3 weeks hence.
All your best.
Item number 3.
May it please your Lordship.
Yes, sir.
My Lord, this is those income tax appeals, my Lord, four in number, decided by a common judgment.
Yes.
And my Lord, we are still on the reference. Lordship has doubted the ratio laid down in...
Sorry?
Lordship has doubted the ratio laid down in Mahari and Sons.
Yes.
And we are still on the reference, your Lordships. Now, my Lord...
Have you indicated the cases that you want to cite to them?
I have given him a compilation, and he too, my Lord, yesterday only filed a compilation.
Very well.
He has given me...
If you are ready to proceed, we'll proceed.
What about Mr. Modi? On his way. My Lord, the only thing, your Lordships, one of the main assisting counsel, my Lord, I'm sorry to say,
Yes.
Mr. Modi, he comes from Guwahati.
Yes.
He's still on the way, it seems.
No, that is all right. If you want to do it, we are ready. You also come from Guwahati?
Yes, Lordship.
All right. Yes.
The point over here is as to whether a partnership firm
Lordship.
will be entitled to the same benefit as an individual belonging to a tribe as per 1026.
Lordship. My Lord, the tentative view of my Lords, my Lord, was that, my Lord, the language of your Lordships, 26A, is saying a member of the scheduled tribe. So a member of the scheduled tribe, my Lord, the indication is there, perhaps the individual income. So if it is individual income, the ratio laid down, my Lord, in Mahari and Sons, there the issue has been decided that it's not only the individuals, even the group of tribals, so long they are doing their business in the tribal area, they are still entitled for exemptions. Only requirement, it should be in the tribal area, number one. Number two, the income is generated from the tribal area. These are two. Now, my Lord, briefly, if I can place the history of this exemption clause, your Lordship, because this has undergone a lot of changes.
1026 has undergone change.
Lordship. Now, my Lord, 1026, my Lord, initially, my Lord, incorporated into the Income Tax Act of 1922, your Lordships, by the Finance Act of 1955. Now, 1926, Income Tax of 1922, your Lordships, these originally, my Lord, framed for the purpose of application in the British India. And, my Lord, so far this part of the country is concerned, my Lord, they were not part of the British India. So after, my Lord, the India attained independence, my Lord, these parts were annexed to the British India, your Lordship.
No, they were not annexed. They were not annexed. Sorry. They requested to be included.
I'm sorry, my Lord, but they became part of the...
Annexation is a wrong word.
I'm sorry, my Lord. They became the part of British India, my Lord. Then came the Constitution of India, my Lord, in force in 1950, your Lordships. Now, Constitution of India, my Lord, created the 6th schedule. So thereafter a need came, my Lord, to, my Lord, grant exemption or whatever privileges to the people of scheduled areas.
We are not on the history may not be relevant.
Slightly,
because we are on the principle that when an exemption is granted,
Lordship,
that provision must be strictly construed. If you come within the exemption, it will be liberally construed in your favor.
Lordship.
That the extent of exemption will be liberally construed.
Lordship.
But as to whether you come within the fold of exemption or not, that has to be strictly construed.
Lordship.
And there is only a judgment of Justice Nariman that you have, where there is a distinction made, but again, that may not apply because that was a case of a number of buildings.
Lordship.
That is the Kerala case.
Lordship.
Number of buildings.
Lordship.
Now, and if it is for a purpose of running a school or the purpose. There, in a school, if it is, let us say a school is exempted, the school will have a gymnasium, the school will have a toilet, the school will have classrooms. Now, if classrooms are over here, toilets are over there, gymnasium is 2 buildings away, will that gymnasium, because it is not contiguous, be considered to be beyond the school? Or will only the classrooms be considered school and the playground will not be considered part of the school? So in that context, that is rendered. So once the school, wider meaning has to be given to that school, but a school cannot be a college. And so therefore, if you fall within that, a wider meaning will be given to you, that where you are doing business and things like that, all of that will be taken into consideration. But when it is a member and of that, then we don't think that we can extend that.
Lordship, I understand. That's why, my Lord, briefly, my Lord, I will not take much time on this, Your Lordship, because it matters, Your Lordship, because there were original provision, my Lord, which was inserted. This was, my Lord, there was a rider, father rider, provided they were not government servant. That was in the original exemption clause, Your Lordship.
Yes, so that was found to be ultra vires.
Lordship.
We are aware of that.
So, my Lord, the Honorable Supreme Court, my Lord, while, my Lord, deciding this, striking down this, or upholding the decision of the Assam High Court, which struck down this classification, one question was raised by the revenue before the Honorable Supreme Court, that since there is a reason why this exemption has been granted, the reason is, my Lord, socio-economic condition of the tribals of the area. So once they hold a government post, they come out from that environment. They become a forward class. Now, my Lord, Honorable Apex Court, my Lord, reacting to this submission, this is not correct. First thing we will have to understand, my Lord, in that decision it has been held that exemption given to whom? Is it given to a person or individual? Said no. And Honorable Apex Court, my Lord, the exact expression is this: individuals as individuals do not come into the picture at all. This has been given to a class. My Lord, if I can kindly rely on that judgment, Your Lordship. Give me that. My Lord, I have filed a further compilation, my Lord, on the last day.
This is the complete compilation, so we won't look at the previous one.
No, yeah, yes.
I don't think.
Yeah, it's there, everything, like L.
Flag L, Your Lordship. Paragraph 14 minus. Paragraph 14. May I read it, madam?
No, not yet. Give us the reference, please.
My Lord, this is 1968, year 1968, my Lord, SC 658.
Where is it? Flag?
My Lord, at paragraph 14.
Flag?
L, flag L, Your Lordship.
Why are you giving a different reference from the reference you've given over here? You've given SCR reference.
My Lord, sorry, my Lord. The equivalent is, my Lord, I'm sorry, Your Lordship.
We don't want equivalent. We'll be looking at this.
My Lord,
Paragraphs differ.
I'm sorry, Your Lordship. 1968 to SCR 165.
Yes.
14.
This has no manner of application over here. What is the provision quoted over here? Yes, at paragraph 5. 21.
Okay.
Any income of a member of a scheduled tribe as defined in so and so, residing in any area specified in so and so, appended to paragraph 6 schedule, provided that such member is not in service of government.
Okay.
Now, what is the distinction?
Okay.
Now, over here, 1026 is included from any source in anyway, let's forget that. So the distinction made over there is that, the submission made over there is that if it's for economically weaker sections or backward people, the moment a backward person is given to a government job, he no longer remains backward. Is that any logic? Is that any logic?
No.
At the end of my career as a government servant, after 30 years, 40 years of service, by reason of the benefits that I get, I may no longer be backward. But just because I get I was exempted till yesterday when I was in a private job, and today I get a peon's job and in a government organization, and I get excluded. That's the basis of the judgment, not anything else.
My Lord, one thing if your Lordship can appreciate, that's my understanding, your Lordship. Now, Lordship will see, my Lord.
Well, the only thing that, Mr. Sen, you can do is on partnership principles.
Lordship.
Because what is a partnership? A partnership is an agglomeration of persons, an associations of persons, of individuals.
Lordship.
And on partnership principles, if you can provide something, then of course it will be acceptable.
Lordship.
Because like a company is a separate entity from the individuals.
Lordship.
Similarly is a partnership firm.
My Lord.
A partnership firm may continue despite the resignation of a partner. A partnership firm may have members who are outside the tribe. It is possible to have.
Possible, your Lordship.
How do you make a distinction between, on the anvil of 1026,
Lordship.
between a partnership firm of individuals who are tribals and are getting their income from the tribal area, and a partnership firm which is registered over here but has members who may not be, or one member who is not a tribal?
Lordship.
Because a partnership firm is also an entity.
It's true.
A registered partnership firm can be sued or can sue.
My Lord.
Whereas if it's unregistered, but that is for the purpose of section 69.
Lordship.
To the extent an individual may have been taxed,
Lordship.
I don't know whether it's possible for that individual to claim exemption. But we are looking at the entity.
My Lord.
And the entity is, according to the Income Tax Act, a separate entity, a separate legal juristic entity than the individuals who form it.
Lordship. Well, and entire thing ultimately comes to that whether this entity, my Lord, because by virtue of being an entity, my Lord, whether I will be entitled for exemption or not.
Let us take, we are discussing this and then we have to broadly look at it. It is possible that I, a tribal, I have an independent income. That does not prohibit me from creating a partnership firm.
Lordship.
So that individual income that I get, that is the one which is protected. The one that I do via partnership is not something which is protected. Just as I, an individual, can have income from the tribal area or I can have income from Timbuktu. The income that is generated from Timbuktu is taxable, despite 1026. The income that is generated within the tribal area will not be.
In fact, my lord, that classification also in tokens in Ringbai, that was challenged. From the tribal area and beyond the tribal area. That distinction was challenged as bad in law, unreasonable classification. But that contention was rejected by the Honorable Supreme Court. Now, while rejecting it, my lord, Honorable Supreme Court has held, there are twin purposes of this exemption. One, to benefit the individual tribal, and number two, to bring about the economic development of that area.
Area as a whole.
Area as a whole, my lord, the scheduled area.
That is none of our business right now. For instance, the area is sufficiently developed, apart from the grant that is necessary for this to go. But that is for the government to decide on a matter of policy.
Exactly.
That's not our business.
Lordship.
But at the same time, we must ensure that what is due to the revenue gets paid to the revenue. Yes, carry on.
My lord, now coming to your lordship, since my lord is on that entity, farm is an entity, your lordship. So now coming to this, my lord.
Because you find several provisions of the Income Tax Act,
my lord,
which indicate.
My lord, admittedly, my lord, this is one of the assessing unit farm. Not denying that, your lordship. Now, my lord.
The only one that is for which there is an exception is the HUF.
Yes.
The
only one for which there is an exception is the HUF.
Lordship.
But that is provided in the statute itself.
Lordship, it's true. It's true, my lord. And my lord, other thing also I have brought to your lordship notice, I think I need to point out. Like my lord Mahari and Son, same parties, your lordships. Earlier also, my lord, on a similar issue, almost a similar issue, your lordship. A judgment was passed by the tribunal. There are also two contentious issues were raised. Whether, my lord, family can be assessed as body of individuals, and then they are entitled for exemption. Then the matter was referred to the Common High Court. Now the Common High Court, my lord, again held your lordships that they have, even if they are body of individual, they are entitled for exemptions. Now from there, my lord, it seems, my lord, the revenue had preferred an SLP. So, my lord, I have got a copy of the SLP, my lord. That SLP was dismissed, of course. That margin will not come, your lordship. But I'm just apprising your lordship.
Of SLP will not.
No. Now, my lord, so far, my lord, entity of the farm is concerned, my lord. The consistent view is this, your lordships, in Dulichand's case. Now, what happened in Dulichand's case, a question came up before the Supreme Court, my lord. If one partnership firm can enter into an agreement with another partnership firm. Now, my lord, there elaborately the status, what is the status and entity of a firm, my lord, that has been elaborately discussed. Now, it has been...
There's a better case than that. It's called firm something, I forget the name. It's called firm something, where all the principles, all the attributes of a partnership firm are better discussed by a Supreme Court judgment.
What is that?
Anyway.
Now, again, my lord, the Chidambaram case. The Chidambaram case, the question came up, your lordships, where the partnership firm owns a tree garden, and the income of the tree garden comprises of, my lord, agricultural income, non-agricultural income. Now, the partners, other than deriving the profit, were also getting a salary. Now, whether the salary will be, my lord, exempted or not, your lordship, that issue came up. Now, the Honorable Apex Court said no. My lord, there cannot be the master-servant relation between the partnership firm and the partners, because partnership firm is not a legal person or a person. So there is no question of entering into a service deal between the partner and the partnership firm. So there they say, my lord, it's only for the limited purpose persona has been attached to firm, your lordship. What is that synopsis?
What are the grounds given in the impugned order?
Impugned order, my lord, strangely, my lord, they have, my lord, relying on this M.K. Chaudhary, my lord, the constitutional judgment, which says should be construed very strictly, declared the judgment rendered by, I mean, ratio laid down in Mahari and Sons as par incuria.
Yes. Mahari was after M.K. Chaudhary or before M.K. Chaudhary?
Much before, my lord. It has been before 91.
In?
1991. It was holding for last 30 years, my lord. Last 30 years.
Mahari didn't go to the Supreme Court.
Mother?
Mahari did not go to the Supreme Court.
It was in their favor, your lordship. They have not gone.
It was in whose favor?
Mahari's favor.
Yes, but the revenue did not go to the Supreme Court.
That's second case, they did not. First case, my lord, which the judgment was rendered by the Honorable Guwahati Court, that a reference was rendered some few months before that. So there the revenue went. But this case, perhaps realizing that they had tried, the SLP was dismissed in earlier case, they did not try it. And another thing also, your lordship, I'll just try to bring to your lordship's notice, the use of the word A, my lord, Article A. Now, Article A has been used here, my lord. Now, Article A has created a lot of confusion, my lord, in other provisions. And ultimately, my lord, the Parliament has to amend it. A was substituted by the word one. Now, my lord, for example, capital gain tax. Now, capital gain tax, my lord, where the relevant provisions say that if I am selling an asset and buying a residential house, then some exemption is there. Now that it came up for, my lord, interpretation before various high courts. Now, high courts held A is not denoting singular or plural. It may be two houses. A is simply, my lord, describing the nature of the property. And ultimately, my lord, if I am correct, in 2015, Parliament brought an amendment.
And made it one residential act.
A has been, my lord, substituted by one. Now, your lordship, look into these facts. Mahari and son holding field for the last 30 years. And even, my lord, though I say doctrine of merger will not come, revenue has gone up to the Supreme Court. The SLP was dismissed. Till days, my lord, they have never tried, my lord, to make any amendments as such. So these also, my lord, clearly indicates, my lord, the intention of the legislature, my lord, as a class, generally exempt them. It is immaterial, my lord, whether they are doing their business individually or as a group of individuals. In both cases. So what I am saying, my lord, Mahari and sons, my lord, the ratio laid down, my lord, is, my lord, there is nothing wrong as such, my lord. This is in keeping with the, my lord, then, my lord, if I can point out one, this exemption further, my lord, there was an amendment in 1998. Now, 1998, my lord, initially it was specific to the Northeast region, tribals of Northeast, 6th scheduled area. Now, in 1998, my lord, they have brought in the people of Ladakh also. Now, my lord, of course, it's not for internal or external aids, your lordships. My lord, I have got a copy of the deliberations of the bill presented before the Parliament. I have annexed there in the compilation. Now, in the bill is categorically say, my lord, exemption by scheduled tribe members of Ladakh. All have been used in plural. And subsequently, my lord, the board which has issued notifications and all, my lord, categorically they are referring to tribals as plural, my lord, not A.
Yeah, tribals as plural, in that context,
My lord.
it's not A, it's all the tribals.
All the tribals.
But they have to be members of the tribal.
Member of the tribals, obviously.
Let us say that, if your analogy if we extend, let us say 10 tribals make up a company. Will that also be exempted?
No, cannot
Then?
be. Well, this corporate personality, of course, my lord, I will not come.
Then?
Because my whole case, my lord, I am relying on limited persona to the farm, my lord, that has been held. Now, my lord, here, since the cases both are tribals, my lord, as a group of tribals, and they are, of course, husband and wife, my lord, family. So, my lord, they, as a group of individuals, my lord, they are running the business, generating their income from the tribal area, my lord. So, considering, my lord, this is a beneficial legislation, my lord. It's needed, my lord, very, very liberal constructions, my lord. And, my lord, if this exemption, my lord, as has been held.
Once you come in,
Lordship.
that's the distinction.
Lordship.
Once you come in, liberally construed. But as to whether you come in or not, will be strict construction.
I should enter the zone first.
You should enter it. Once you enter,
My lord.
very liberal.
Lordship.
But whether you enter or not, strict.
My lord. But again, your lordship, it will depend here, my lord. I am unable to, my lord, read minds of your lordships. Unable, my lord, whether your lordship will, my lord, review the ratio laid down in Mahari and Sons. If lordship is reviewing the Mahari and Sons, my lord, then of course, my lord, I will be out. Because I am hugely, my lord, depending on this ratio laid down in Mahari and Sons. If your lordship held that Mahari and Sons is not a good ratio laid down, then of course I am out.
That is probably the
That is the crux of the issue, my lord.
That is
so, my
probably
lord,
the
I am
likely thing.
trying to pursue your lordship's.
Because then we'll have to agree with the impugned order that this is per incurium. We cannot overrule it because it's a common high court But what we can do is, if it's per incurium, then anyone can say it's per incurium. As long as it's per incurium means in ignorance.
Yes,
Per incurium can also be not in ignorance, but the law is rendered bad by events subsequent to the law being laid down. All of Mari is based on beneficial legislation, wide interpretation of exemption, which is directly contrary to that M.K. Chaudhary.
Obviously, my lord.
Directly contrary to that. So if there is any law laid down on principles which are subsequently reversed by the Supreme Court, then the principle on which the previous law has been founded is rendered bad.
So my lord, entire case is hinging on this.
It's hinging on that.
Ratio laid down, my lord.
It's hinging on that.
So, my
of course, there are one or two things in your favor.
lordship.
The biggest thing which is in your favor is that it is holding the field for
Long
a
time.
period of 30 years.
Yes.
And therefore, what is a settled position should ordinarily not be disturbed. That's the principle of stare decisis. But the principle of stare decisis is not limited over 30 or 40 years. Principle of stare decisis is over a period of a century or so. Stare decisis is not over 30, 40 years.
That's true, man. So this is one thing, and my lord, to my knowledge, my lord, whatever I submitted, my lord, because these are the
we also find the other thing which is in your favor is that we also find that there was a little bit of adventurism by the
tribunal.
Because the tribunal should have been, instead of just blasting it away, should have probably, because there were similar views taken by tribunals, benches of same strength.
Lordship.
I don't know whether it is possible to constitute a larger bench within the tribunal, but this matter should have probably been referred to a larger bench within the tribunal. And that is one area where, we are minded, because this thing that 30, 40 years is a long time in independent India. No. Even though strictly speaking, the doctrine of stare decisis may not be applicable, but we may still extend it because it has held the field for such a long time. Whether it is per incurium or whether it is rendered bad law in view of subsequent Supreme Court judgment or not, should have received much greater consideration than has been given in this judgment. That is one way we can, set aside the matter. If there is a possibility of a larger bench being constituted within the tribunal,
I think they have a power.
Require that to be done, because please also, we have got to respect the other thing also. There is a principle that when there is a specialized tribunal dealing with a branch of law, then the view expressed by that has to be given sufficient respect even in exercise of judicial review. So this is a view expressed also. All these specialized tribunals, all these, 323A particularly, may not be 323B.
In fact, twice. This Mahdi and Sons went before the tribunal twice. And twice they have given their view on this. So that also, my lord, what your lordship is saying, that should have been.
There is a concept of larger bench.
And there is a concept of larger bench.
Is there?
I have to.
Because that is then what we'll do. Because this is, after all, been a settled position for a long time. And once it's a settled position, people plan their activities in a particular way. And you constitute a larger bench, and we'll direct that for this to be done. And thereafter, whatever the view is expressed, we'll give you some time. We'll give you 6 months or so. And then thereafter, it can be looked into by us. But it is rather cavalier. Please don't get us wrong. I'm not one of those judges who thinks that just because a High Court has done something, a lower body cannot say per incurium.
Lots.
In my life, I have destroyed several Supreme Court judgments by calling them per incurium, even on the single bench. Per incurium means per incurium. And anyone is entitled to, even a passerby can call it per incurium, even if it is a Supreme Court judgment. But it's been done in a rather cavalier manner. You know, when I say a judgment which is rendered by an authority which is superior to me, whose judgment is binding on me, say I'm a single judge saying that division bench judgment is per incurium. I'm a High Court, I'm saying that the Supreme Court judgment is per incurium. I have to do it with a lot more responsibility. I have to, see everything before I do it.
That is correct.
It can't be done in one line. Over here is just one reference and somewhat. And then they also ought to have taken into consideration the principle that it's remained settled. This is the settled law. As you know, in law, they say the life of law is not logic, it's experience.
Yes, Lord.
And similarly, res judicata stare decisis are not on correctness of judgment, but on finality of an order or finality of a principle. They may be incorrect, but that gives certainty.
Lordship, for making one submission, in Mahari's case, Lordship, the observation in paragraph 15, we are therefore opinion that the income earned by a Khasi family as a unit would be entitled to exemption under section 1026. Here, Lordship, admittedly, this is a registered partnership firm, and that is to be assessed under the chapter 6.
This is a registered partnership firm?
Yes, Lordship.
Registered partnership?
Yes, Lordship. It's a registered partnership firm. Under chapter 16, the firm is to be assessed as a partnership firm, Lordship, because the legal entity, Lord.
Where is your deed? Does the deed limit membership of partners only to tribals?
Lordship, page 65 of my affidavit, Lordship.
Then we can finish it. If the deed does not restrict it to tribals, gone.
But it is within the family only.
Within the family is irrelevant.
Lordship, there is no
Registered it.
There is no recital, I think, Lordship, what Lordship has queried about, but that is not mentioned anywhere in the deed, Lordship. Whether it is restricted to tribal family only, Lordship.
Just it's not registered. Both are registered. This
This is already restricted.
Is there a dissolution provision?
Well, I'm just looking.
Just see the dissolution provision towards the end.
Any matter renewal specific shall be all the questions.
Dissolution, replacement,
Shall be decided by
retirement,
or each makes steps to time as made.
addition,
The partner is named.
Under the Partnership Act, partnership is limited between the partners who join the hands. Other party cannot join under the Partnership Act.
just give us the deed.
Lordship, we have annexed in our affidavit.
Just look at it, more convenient there.
Lordship.
We'll give it back to you. Just.
If you can join. If you can join.
We can-
But one more copy. This during the assessment period, this is the situation.
This form under the income tax act has same definition as given in the partnership. Partnership.
This was the position when assessment was made.
So partnership deed is initial nothing around. Given in the Do you have the decision of Tulicham Lakshmi Narayan?
Clause 16. The partners, namely of the first part and second part, may by mutual consent decide to have one or more partners to join this business of the firm at such stage and on such terms as may be mutually decided. It is as open as it can be.
It's true. The only thing your lordship say here,
Tulicham Lakshmi Narayan did. Just take that compilation.
Yes. Just give it back.
Lordship, further, they applied for the PAN card. Lordship, in paragraph 2 of our affidavit, we stated that the SEC is a firm and having permanent account number, PAN number so and so. The SEC had knowingly applied for the PAN card with the status of firm, which is evident from the permanent account number. Then the classification has been given, what it denotes the number.
That could have been mistakenly done by way of abundant caution. If they are entitled to in substance, then
No, that is, Lordship.
then that has to be, if they're entitled to the benefit, it has to be extended to them.
my lord, what I am saying, my
That will
lord,
not make a difference.
for the concern assessment here, my lord,
Just try and see. We'll have to think about it, Mr. Sen. Just think about it today. Then how do you extend 1026? Then will the revenue look at the composition of the partnership firm
lordship,
before according it exemption or not?
that's true.
That is not the intention of 1026.
Lordship, obviously, my lord,
And today we will say, based on the present composition,
lordship,
the firm is exempt.
my lord,
Firm is exempt for 5 years.
lordship,
The two partners agree to take a North Indian for a partner. Then what was exempted by virtue of the constitution of the partnership firm becomes under what provision?
obviously cannot, my lord.
How does 1026 deal with these situations?
My lord, my whole case is your lordship, because so far this partnership is concerned, my lord, concerning the assessment year from which this appeal has arisen. The fact is, this is undisputed fact, because they have admitted in their discussion in the judgment.
In Maori,
both the partners
was it a registered firm?
no, it is a family
It's a family business.
business as a body of individuals. Now, my lord, so far this assessment period, my lord, there is no dispute, my lord. They have said yes, both the partners are tribals. They are otherwise, my lord,
Maybe.
so that has been happened,
Tomorrow you add a third partner,
lordship.
and
Then
then
I am not.
Then I will not.
Then I am not, your lordship. Then it will be a business, my lord, comprising of 3 partners. One of the partners who is not eligible, my lord. So that will render
fit it into 1026.
It will not, my lord.
No. Fit the different situations in 1026.
When a non-tribal will join the firm, it will not be joint income of members of scheduled tribe.
Then we have to read so many things into
No,
1026.
lordship, what will happen is normally what we are referring to joint income. Now, joint income of tribals, that is the core issue here, lordship. Moment a non-tribal comes in, my lord, we cannot say it is joint income of the tribal. This is to be a joint income of the tribal. Because our whole case is joint income of the tribals. And here, my lord, coming the husband and wife, my lord, and it has been admitted in the judgment also.
Maybe.
Lordship.
They're individuals as individuals. It has to be.
Moment, my lord, somebody else enter into, my lord, it cannot be like a North Indian or somebody else, your lordship. It cannot be a joint income of tribal. Because our whole case we are basing is joint income of the tribals. If it is not a joint income of tribals, my lord, we cannot invoke 1026. We are not authorized to invoke 1026. But so long it is joint income, my lord, we will obviously rely on the ratio of, my lord, Mahari and Sons. We will obviously, my lord,
We find that to be very difficult to accept.
lordship.
That till such time that tribals, let us say, on the last day of the year,
Lordship.
you induct an outsider. Then what part of the income will be taxable, what part of the income will not be taxable? These are things which are there are many difficulties which will arise.
But here
And
you can
therefore,
take a
we have to give a restricted meaning.
My lord,
Unregistered firm, it's a different thing. It's an association of individuals.
lordship.
You can't sue them by AB company or AB firm.
Lordship.
You have to sue them as
Division.
A and B and C, depending on number of partners.
Right.
They are individually, jointly and severally liable.
The only difference, registration makes.
In partnership law, ultimately they become jointly and severally liable.
Well.
But first is you proceed against the assets of the firm. It's only when the assets of the firm are exhausted and it goes to dissolution that you look at, unlike a company.
Lordship.
And which is why a company wears a different tag. The word limited. Limited is a warning to the world that the owners of this entity have only limited liability. So if the company has 100 rupees worth of assets and you are a creditor, you have a 1,000 rupee claim and there is no other creditor, you will get 100 rupees. Despite the members of the company being millionaires, you can't go to them.
Right.
Whereas against a partner you can,
Whether it is registered or unregistered.
depending on the deed, depending on the wording of the deed.
My lord, here
But these are complexities which are not to be taken into account in 1026.
my lord, one submission if you can make, my lord. We are from a judgment, my lord, rendered by the tribunal. Now, so far, my lord, judgment is concerned, my lord, they have admitted the fact. This is on the basis of this partnership deed, your lordship, where both husband and wife both are tribal. They have admitted there is no disputes, the both are tribals. So, my lord, this is pertaining to this judgment.
Very well. When you are attacking a judgment, if there is one aspect which is ignored, we can embellish that. We can add our reasons to justify that judgment.
My lord, considering other aspect, your lordship.
There's nothing stopping us from doing that.
My lord, I understand, your lord. Considering the other aspects, my lord, the ratio laid down.
Forget that. That ratio will not apply to an unregistered firm now. To a registered firm.
Registration.
That is an association of individuals.
My lord.
This is a registered firm.
Even a registered form, your lordship, otherwise, my lord, what has been held, my lord, consistently, my lord, is very limited purpose. They have the persona, my lord, attribute of persona, very limited.
For the purpose of revenue, they have the persona. It has the persona.
Only for the purpose of assessment, that too.
No, this is true, my lord. They are an independent assessing unit, my lord. I am not denying that, my lord. But when, my lord, this nature, my lord, when the income is the joint income of the tribals, my lord, and both the members are tribals, your lordship.
Tell us what is the provision for constitution of a larger bench by the tribunal?
See,
No, sorry.
my lord.
In the tribunal rules, it is there. Look at the act.
Give us the Income Tax Act. Let us see. Let us also look at that aspect.
This is
Section 255.
Section 255, my lord.
Section 4.
255, subsection 4.
section 254.
My lord. 255 4. Subsection 4.
Members differ, and it can be referred to third member. Suppose third member offence are not larger bench.
There's difference of opinion.
Yes, Lord.
Where is the power to constitute a larger bench?
I think there is no such power, Lord.
There's only upon difference of opinion.
Practically, they follow the same procedure. It may be in the income tax settlement.
There's no such power.
My lord, I think what my learned friend is saying, it might be there in the rules. They have set of rules, income tax rules,
Tribunal rules.
tribunal rules, your lordship.
How can the rules have been framed by who? Central government?
Yes, yes, Your Honor. And they follow, this is the common practice, that they constitute the larger bench. Day in, day out.
Larger bench, yes. 255(4) allows a difference of opinion.
That we call it third member bench. And when a division bench differs from a division bench, coordinate bench, at that time larger bench is constituted in the similar manner. The president of the tribunal has the power. We have third member bench, larger bench, and special bench.
They're in the rules.
I'm not sure about that, Your Honor, but practice, we are observing that in the practice.
No, but there has to be some
Yeah.
thing in that. Are you aware?
Lordship, I'm not aware. I have to.
Then we will do either of two things.
Lordship.
One is if we see that it is a possible view, notwithstanding Maori having held the field for a long time,
Lordship.
then we'll ask the tribunal to constitute a larger bench to look into this aspect, various aspects, because that is a specialized body.
Yes, Lordship.
Otherwise, we might rule in favor, hold that Maori is still good law.
But in my humble submission, Lordship, the Maharis, there was the individuals.
Mahari or what, yes.
There is two individuals, Lordship. Their case was that being a family business, they are entitled to exemption. But here, Lordship, as I have submitted, this is a registered partnership firm. And under chapter 16, the firm is to be assessed separately, Lordship, being as a legal entity.
A firm is to be assessed separately.
Yes, Lordship.
But there is also provision that if the composition of the firm undergoes a change in the previous year, then for the subsequent assessment year, the documents have to be produced whether it holds good or not. So if that is the thing, then if an outsider comes, as long as tribals are there,
That is,
exemption will be granted. But if an outsider is inducted, immediately they will not be eligible for exemption,
even if it is a registered partnership.
even if it is a partnership firm. Then we would be giving respect to Maori or Mahari or whatever it is, which has held the field for a long time. That would be reconciling both. Because look at it in the in the context of what is there. We are not looking at the outside. There's a lot of abuse which is happening outside, but let's forget that. Let's concentrate on this. The business could have been run only by the husband, where he would have been completely exempt. The business could have been run only by the wife, where she would have been completely exempt. Now, it's nobody's case that they are divorced or separated or something like
No,
that.
that is not the case.
So if they are running it jointly, why should the family principle, which is not there in Mahari, not be applied? And we'll restrict it to that. On the ground that if there is any change in composition, then as to whether exemption will apply or not will become an open question. But in the circumstances of the present partnership, which is of husband and wife, both tribals, and the income is within, since you don't dispute those grounds, Mahari will hold good.
In other three appeals, probably position is different. Although these are partnership firm, but they are not blood relation.
They're not,
They are not blood related, Lordship.
but they are
Tribals.
tribals.
Not.
So we'll just not make it blood related. We'll only say as long as the composition of the partnership firm is restricted to tribals. If there is any change in the composition, then the question will become open and the revenue may decide in accordance with law.
In my humble submission, Lordship, first proposition led by your Lordship, I think that will be better to decide the dispute for once for all, Lordship, by referring the matter to full bench, Lordship.
That is subject to your seeing whether that full bench is possible or not.
Lordship, then I'll obtain.
If that full bench is possible, because neither of you can indicate to us, if that full bench is possible, we'll consider.
I'll, Lordship, allow me 1 day or 2 days time. I'll get back to your Lordship.
Get the rules or whatever. You can also do that. Get the rules or whatever. But even after looking at the rules, we'll think over this, whether we'll choose the second option or not.
Lordship. That.
When will it be convenient?
Lordship, within next week, Lordship, any day.
Next Wednesday?
Next Wednesday, tribunal bench is there either Tuesday or Thursday.
Let the matter stand over.
Lordship can make it either Tuesday or Thursday.
Very well, Thursday.
Lordship.
Let the matter stand over for a week for the parties to produce the rules relating to the composition and constitution of benches before the Income Tax Appellate Tribunal.
Tribunal, Lordship.
CAT.
CAT.
What is it called?
Income tax.
Income Tax Appellate Tribunal.
Income Tax ITAT. Yes. Then give the date Thursday.
Lordship.
Obligation.
Item number 7.